on the ones that we did not. So my name's Anna Koeppel. With me is my colleague and attorney, Ganapathi Ramaswamy. Ganapathi, you want to say hello?
Hey everyone, nice to meet all of you.
Yeah, and Ganapathi and I will be giving this presentation together, sort of trading off between the slides. And like I said, we will do some frequently asked questions throughout. So
Anna, if you want to share your camera, if you stop sharing your screen, I think I can allow you to share your camera. I don't know how to do that.
Well, I tried to turn on my camera, but it says I can't start my video because the host, I don't know that I have permission.
Okay.
But we can, we'll when it gets to like FAQ time, we'll
Okay.
go on.
Perfect.
Yes.
Perfect.
There we go. So, like I said, like Jerry said, we're here today because of the Paid Leave for All Workers Act, which is taking effect January 1st, coming up here. A little bit about the Illinois Department of Labor. We are a state agency. We are charged with enforcing laws, protecting workers' rights on the job. We administer and enforce about 25 labor laws, including this paid leave law, but also laws such as the minimum wage overtime law, the Equal Pay Act, the Prevailing Wage Act, and many others. And we have offices in Chicago, where Ganapathi is, and in Springfield, where I am, and then also in Marion. We have 3 labor law enforcement divisions currently: Fair Labor Standards, Conciliation and Mediation, and Illinois OSHA. And then we actually are have our directors created a new division for leave rights, which will enforce this paid leave law coming in 2024. We have new staff starting in January. So a little bit of background about this act. This was passed by the General Assembly, the Illinois legislature, back in January of this year. So it passed about 11 months ago. The General Assembly finds that it is in the public policy interests of the state for all working Illinoisans to have some paid leave from work to maintain their health and well-being, care for their families, or use for any other reason of the employee's choosing. And that actually is in the law. Illinois is one of only 3 states with a paid leave for any reason law. I want to emphasize that this is not a sick leave law. This is not a law that provides paid time off only if the employee is sick or has a doctor's appointment or family member sick. This is leave that the employee can use for any reason of their choosing. And the act says the provisions of this act shall be liberally construed in favor of providing workers with the greatest amount of paid time off from work and employment security, meaning that it's job protected, the worker cannot be penalized or lose their job for taking the leave that is protected by this act. So the format of today's presentation, as I said earlier, we've done this presentation a number of times. We update it almost every time to address new frequently asked questions that we've gotten from the audience and our email. We'll do questions at the end. Please understand that we, as we give this presentation, there may be some people here who are very familiar with this law. They've read it, they've read our FAQs, they've read our proposed rules, and there may be people here who are hearing about this for the first time. So trying to cater to both audiences here. And we do have FAQs on our website. We encourage you to check those out. And I believe Jerry is recording this webinar, so he may be able to share it after we're done here. And I'm going to hand it over to Ganapathi, my attorney, to talk about compliance.
Thanks, Anna. So this presentation is intended to offer general guidance on the provisions of the Paid Leave for All Workers Act. As you're probably aware, the Department of Labor cannot give legal advice. This is just general guidance, best practices for compliance, coming to compliance with the act. Employers should consult their own legal counsel to determine what actions they should or should not take in order to comply with the law, including any situation specific to their business or operations. So let's go over the agenda for today. First, we're going to talk about who's covered under the act, including employees and employers. Then we're going to go over providing paid leave, whether it's through front loading or accrual. Then we're going to go over using paid leave, how employees can request and use paid leave. We're also going to go over other employer responsibilities under the Act. We're also going to cover penalties and how the department will be enforcing the Act. We'll also talk about some frequently asked questions, both throughout this presentation and also on our website. And as Anna sort of explained as well, we'll also run through some commonly asked questions throughout this presentation, and then we'll finish up with a question and answer session at the end. And I think most relevant for this presentation is that this law applies to any employer, including municipal employers, who doesn't already have a qualifying pre-existing policy and who isn't already covered by a local paid leave or paid leave ordinance in effect on January 1st, 2024 that meets the minimum standards of the Paid Leave for All Workers Act. Any questions regarding the Chicago ordinance should be directed to the City of Chicago Office of Labor Standards, and questions regarding the Cook County Paid Leave Ordinance should be directed to the Cook County Commission on Human Rights. Back to you, Anna.
I was talking and muted, of course. Thanks, Ganapathi. So a couple of main takeaways we want to start with, and we'll go over these again throughout the presentation, but these are the highlights. These are the headlines. Any employer who has a bona fide pre-existing policy that allows all employees to take 40 hours of paid leave for any reason of the employee's choosing is not required to modify the terms of that policy in order to comply with this act. Also, employers may enact reasonable, clearly communicated policies that establish circumstances in which the employer may deny an employee's request to use paid leave due to operational necessity. Employees should know where they stand and be able to plan ahead to use their leave. Okay, so who is covered by this law? So as I said a minute ago in our main takeaway, I want to talk about, are you covered by this law if you have a pre-existing leave plan? So if you already offer PTO, paid sick leave, or paid vacation, do you have to add time to that, or do you have to change anything about your plan to meet the specific requirements of this act? And the law says that if you have a pre-existing plan that provides for 40 hours of leave each year for any reason, you don't need to modify the terms. This must be true in fact. You must have a bona fide policy meeting the minimum amount of leave set in Section 15A of the Act, which is 40 hours, and all your employees can take that amount of leave, in fact, for any reason each year. You don't need to modify the terms or add to your pre-existing policy. I will say, up at the top, I referred to paid time off, paid sick leave, paid vacation. Please note, paid sick leave probably will not qualify for this provision because sick leave is usually limited to use for certain reasons, such as, actually being sick or having a doctor's appointment, or your family member has a doctor's appointment, that sort of thing. This leave, in order to qualify, must be for any reason of the employee's choosing. Also, your pre-existing plan must apply to all of your employees in order to qualify for this provision. If you exclude part-time employees or you exclude new hires, right, in their first year, they don't get vacation until their second year, then you likely would not qualify for this provision because not all of your employees get 40 hours a year. So you may want to modify in order to, see if you can qualify for this exception. So I am going to pass it back to Ganapathi. Talked about some definitions.
Thanks, Anna. So who's covered? Let's start with the definition of employee. Employee has the same meaning as the definition of employee in sections 1 and 2 of the Illinois Wage Payment and Collection Act, plus a few additional categories. So part-time, temporary, and seasonal workers are also considered employees under the Paid Leave for All Workers Act. All domestic workers, nannies, and housekeepers are also considered employees under the Paid Leave for All Workers Act. Employees of state and local government agencies are also considered employees, and interns are if they're considered employees under the Act. Who's not considered an employee? Again, we look at the Illinois Wage Payment and Collection Act to determine who's not considered an employee. Those that are considered independent contractors are not considered employees. So how do you determine if they're an independent contractor? Well, the Illinois Wage Payment and Collection Act has an independent contractor test. There's a three-part test. First, are they free from the control and direction over the performance of work? Are they performing work, which is either outside the usual course of business or is performed outside all the places of business of the employer? And is it in an independently established trade, occupation, profession, or business? The three factors indicate whether a worker is really a true independent contractor or is an employee covered under the Paid Leave for All Workers Act. What about union employees? Employers and employees covered by a collective bargaining agreement that is in effect on January 1st, 2024 are grandfathered in for the duration of the pre-existing agreement. Just be aware that union, construction, and freight employees are not covered at all. We'll talk about that in the next slide. After January 1st, 2024, parties may waive the Paid Leave for All Worker Act in new contracts or contract renewals only if that waiver provision is clear, explicit, and unambiguous. So, for example, a CBA or an agreement or a bargaining agreement is signed effective July 1st, 2020 and expires on June 30th, 2024. Parties will need to address a possible waiver when they negotiate a new CBA on or before July 1st, 2024. If no waiver is agreed to and added to the contract, the employer must comply with the law, although parties may want to bargain over individual provisions of the employer's policy. So what's the best practice going forward? From January 1st, 2024, consider inserting language in a collective bargaining agreement regarding Paid Leave for All Workers Act, whether waiving it or not. And remember, if you're waiving it, it's a best practice to make sure that it's explicit, clear, and unambiguous as required under the Act. And please be aware that different CBA provisions apply to state agency employers and employees. Consult your HR or your union representative. Who's not covered? Employee exceptions. Some groups of employers and employees are specifically exempted from the Paid Leave for All Workers Act. Certain railroad and airline employees, certain higher ed employees, collective bargain covered union construction work, and collective bargain covered union package transportation and delivery workers as well. These are domestic and international freight employees. And then now that we've covered employees, who are considered employers? Again, similar to employees, employer has the same application and meaning that is provided in sections 1 and 2 of the Illinois Wage Payment and Collection Act. Except for the purpose of the Act, employer also means state and units of local government, any political subdivision of the state, or units of local government, or any state or local government agency. Employer does not include school districts organized under the school code or park districts organized under the park district code. And also, employer also includes employment and labor placement agencies. So these are typically your staffing firms. So they're also included under the definition of employer. Back to you, Anna.
Okay, thanks, Ganapathi. So want to get into some frequently asked questions here. May municipalities or counties opt out of paid leave in order to provide fewer hours of paid leave than what is required under statute?
And that would include townships.
Yeah, my understanding is that municipalities is a term that we're in the weeds here, but municipalities is a term that can refer to not just cities and villages, but other units of local government. But that is something that your all's attorneys would know much more than me. So the answer here is no. We recognize that there's a section of the law that provides an exemption for municipalities or counties with a local ordinance in effect prior to the effective date of the act, if that ordinance requires employers to provide any form of paid leave. However, Section 5A of the act sets the statewide minimum standard for the amount of paid leave that employers, including municipalities or county employers, are required to provide for their employees. And that statewide minimum standard is, as we've said, 40 hours. So any local ordinance that is enacted or amended after the effective date of the act must comply with all paid leave for all workers act requirements. So given the potential legal implications of these laws, it is absolutely recommended that you consult with your legal counsel prior to changing or enacting any policies, laws, rules, or regs. A couple other frequently asked questions. I don't know if this will apply as much for this audience, but does this apply to remote employees, and does it apply to employees who live in Illinois but commute to Indiana for work every day, or vice versa? They live and work in different states. So because there's a number of possible configurations of remote work arrangements, it's hard for us to provide a one-size-fits-all answer, but we will say we've traditionally found that Illinois workplace protections apply to employees who are primarily perform work in Illinois for a company or employer that is doing business in Illinois. We have proposed more specific factors in our proposed rulemaking that you can use to assess if any given worker is covered by this law. So provision and use of paid leave. We're going to use the terms accrual versus front load throughout this presentation. So accrual and front loading are the two different ways employers can choose to provide paid leave. It's up to the employer to design a paid leave plan that works best for them and their employees, whether that's accrual or front loading. So accrual is when an employer has employees earn 1 hour of paid leave for every 40 hours worked. Employees can accrue up to 40 hours per year. So a part-time, temp, or seasonal worker is entitled to earn paid leave under the Act. Part-time, temp, seasonal, not excluded from this act. They are covered by this act. But because they work less, they might never accrue a full 40 hours of leave in 1 year. So for example, if you have an employee who works 10 hours a week, earns 1 hour of paid leave every 4 weeks, they work 50 weeks a year, they're going to earn approximately 12 hours a year. And then, as I said, the other way to provide leave benefits is to front load it. So instead of requiring employees to accrue leave gradually throughout the year, employers can make 40 hours of paid leave or a prorated amount available to employees at the beginning of the 12-month period. And the 12-month period is up to you. It doesn't necessarily have to be January through December. It's determined by the employer. So if you have a fiscal year that's July 1, you can set that to be your 12-month period. You can use each employee's anniversary date. But if at any point you want to change this 12-month period, you have to provide advance notice to your employees in writing. And please note that if you do choose to front load benefits, you cannot retroactively diminish those. And what that means is if you front load 40 hours of leave for somebody and then they quit before the end of the year, can you make them pay it back? No, you may not. So here's some frequently asked questions. And then I know there's a couple questions folks had that I'll cover a little bit too. So there are these 4 frequently asked questions, which are all sort of based in the same principle. Can we front load less than 40 hours for part-time workers? Can we prorate front-loaded paid leave for employees who are hired mid-year? Can we match our paid leave 12-month period to their fiscal year and or an employee's hire anniversary date? So the answer is yes. The employer may design the front-loaded leave to be prorated according to their business practice, so long as the amount of leave provided is 1 hour of paid leave for every 40 hours worked. So that means you can front load paid leave for part-time employees at a prorated amount consistent with the employee's anticipated work schedule. But if they end up working more than you expected, you have to add time. They're entitled to accrue more time. And if they end up working less than you expected, you cannot take away time that you've front loaded. Similarly, let's say if you your 12-month period you set as January through December, you hire an employee in July, mid-year, you can front load 6 months worth of paid leave for the last half of that year. And then the following January, they would get a full year's worth of leave, just like everybody else. And sort of the reverse, for next year, for 2024, let's say you want to follow a July to June fiscal year, you could count January 1st, 2024 through June 30th as half a year, provide leave on a prorated basis for that 6 months, and then start a new 12-month period on July 1st. I want to say that as employers, there are pros and cons for either method, for front loading or for requiring accrual. There's pros and cons either way for you. You just have to determine what's going to be best for your situation, your preferences, and what'll work for your employees. Can we front load 40 hours for full-time employees and accrue for part-time employees? Sure, you can have separate policies that provide paid leave via front loading for some employees and via accrual for others, but those policies must be applied consistently, communicated ahead of time, outlined clearly in your written policy, and not done in a way that's illegally discriminatory. And the law does not allow an employer to make an employee repay paid leave time that was front loaded. This also applies if you front load paid leave according to an employee's anticipated work schedule. If they end up working less than expected, you cannot take back or make them repay their used or unused paid leave. Okay, I also wanted to, I know we were asked to address whether elected officials are employees. And the answer there is, it depends, and you really need to consult an attorney, because the law doesn't explicitly say clearly one way or the other whether elected officials are employees or not, or whether they're covered by this act. So it may depend, you know, across the state, there's all kinds of elected officials, everybody from the governor to state legislators to township officials, city council, township clerk. I mean, there are, whether those people are an employee performing work is something that your attorneys will have to do sort of a case-by-case assessment on to see if they meet the definition of employee.
If I could interrupt there for a second, because that's going to cause a lot of questions. I know we have AG opinions that elected township officials are considered on call 24 hours a day, 7 days a week, and no township officials in Illinois get benefits at this point because of their elected status. But again, if you're recommending they check with their attorney, that's always been our association policy forever.
Yeah, we can't, I guess I agree. I would recommend consulting your attorney.
But well, not all townships have attorneys. Some of our townships don't even have an office. And we have repeatedly indicated that elected township officials are not considered full-time employees by an AG opinion. So I'll look into that, and we'll get an opinion for anybody on the call that's interested. I'll get that validated so that we can do it statewide.
Sure. And if you want to, I mean, if you want to, we can possibly address this in a future FAQ as well. So if that'll be helpful.
Okay, thank you.
If there's pre-existing case law or AG opinion that answers that question,
and there is,
then I would say that, you know, not having read it, but that seems like a great place to start to how to develop your policy.
Absolutely.
And where the rubber meets the road would be, right, like if you had a township official who believed that they were entitled to paid leave from the township. They were not getting paid leave from the township. They filed a complaint with us. They choose to open an investigation, and then the township's defense could be, look, we don't believe, you know, them to be an employee or whatever it is. That's how that would come to be like worked out. So let's see. I know there were also some questions about seasonal workers. And like I said, they're not exempt. So, you know, you may want to have them accrue based on actual hours worked. But regular part-time workers with set schedules, they're not exempt. They're, you know, treat them as you treat anybody else. Okay. Trying to advance. Okay, back to Ganapathi for overtime exempt information.
Thanks, Dana. So what are the provisions for overtime exempt employees? So these are folks like managers, professionals, some salaried staff who work more than 40 hours a week. Generally for administrative, executive, professional employees who do not get overtime under the Fair Labor Standards Act, as it's under federal law. The earning rate would cap at 40 hours worked per week. So generally employees that meet that exemption accrue at 1 hour per week, even if they work more. So as an example, obviously not necessarily relevant for this audience, but for similar workers as well, a manager at a retail location, if they are FLSA exempt management and they work more than 40 hours per week, the manager may be deemed to work 40 hours per week for the Paid Leave for All Workers Act accrual purposes. So if you do have folks who are in this category of managers, professionals with some salaried staff who are FLSA exempt, this would be an applicable provision. I do recommend you just carefully review the Fair Labor Standards Act definitions. So when can employees start using paid leave? So paid leave shall begin to accrue or must be front-loaded on January 1st, 2024, or upon the start of employment for employees hired after that date. And then employees shall be entitled to use paid leave 90 days after January 1st, 2024, or 90 days after starting employment for employees hired after that date. The 90-day waiting period only applies once for any given employee for the duration of their employment. So it's either January 1st, 2024 for current employees or upon hire for future employees. What's the rate of pay for paid leave? So section 15F discusses the rate of pay, and employees shall be paid their regular rate of pay for time taken on paid leave. And just be aware, again, less relevant for this audience, but tipped employees shall be paid at least a minimum wage in the jurisdiction where they work. So if an employee requests paid leave, how does that work? Employers must allow for oral or written requests to use earned paid leave. Section 15H states that employers can have a reasonable paid leave notification policy. If the leave is foreseeable, employers may require 7 days notice. If it's unforeseeable leave, notice may be required as soon as practical. Also, and here's our guidance. If this area requires employers to carefully consider the operational needs, the term reasonable and foreseeability in light of the right of the employees to take time off for any reason. Basically, what this is saying is that you can have a reasonable paid leave notification policy for foreseeable and unforeseeable leave, but you must balance out this reasonable policy with the right of the employee to take time off for any reason. An employee may choose to take paid leave, choose paid leave provided under this act prior to using any other leave provided by the employer or state law. So if there's any other leave available by the employer or state law, whether it's unpaid or paid, the employee may choose whether to use this paid leave provided under this act prior to using any other leave. Now, employers can deny the use of paid leave. Employers may enact reasonable, clearly communicated policies that establish circumstances in which the employer may deny an employee's request to use paid leave due to operational necessity. This must be in the employer's written employee handbook and distributed to all employees.
Okay, I'm going to discuss carryover. So does paid leave carry over from year to year? And the answer is it depends. So as you, the employer, whether you choose the accrual method or the front loading method, that will determine if the unused paid leave carries over. So generally under this act, an employee's unused paid leave that was provided by accrual shall carry over annually. Conversely, front-loaded leave does not have to carry over. Also, the employee is only entitled to use 40 hours each year unless the employer chooses to allow them to use more. And I want to note that even part-time employees are entitled to use 40 hours each year if they have that much in the bank. So if they only work 20 hours a week and they accrue 20 hours 1 year and they use 8, so they roll some over and then they accrue another 20, they can use up to 40 hours, whatever they've got in the bank, even if they don't necessarily accrue that much in a year. Okay. Frequently asked questions. So first frequently asked question, probably highly relevant to this group. Can you deny an employee's request to use paid leave? Can you set times of the year when use of paid leave is limited? Can you restrict use of paid leave for emergency responders or people who, or provide critical services? Nothing in the act prohibits an employer from adopting a policy that establishes some parameters for taking leave and limited reasons the employer may deny leave for operational necessity. Any such policy must be reasonable, communicated to employees, applied equally to all employees, and conform with other applicable state and federal laws. So if you're worried about, snowplow drivers or something like that, really think about how would you pre-design your policy to balance, your operational needs, but also being mindful that these folks do have paid leave available to them to use throughout the year. And what about no call, no shows? An employer can adopt a reasonable policy regarding how they will handle no call, no show absences, but employers in the law cannot require the employee to disclose the cause for the absence. Can employers force employees to use this paid leave time if their employees request unpaid leave or some other form of paid leave? Can I require employees to take sick time before using this paid leave or vice versa? And the answer is that the law says an employee may choose whether to use paid leave provided under this act prior to using any other leave provided by the employer or state law. So that means if you, the employer, have another paid or unpaid leave policy or practice, such as sick leave or unpaid leave, the worker can choose whether to use this paid leave before using that leave. Now, for FMLA is a federal law. And remember, the state law says an employee may choose whether to use paid leave under the act prior to using any other leave provided by the employer or state law. FMLA is a federal law. Employees going on FMLA may use paid leave time concurrently during their FMLA period. We, the Illinois Department of Labor, don't administer or enforce FMLA, and all FMLA questions should be directed to the USDOL. Okay, another common question. Because employees may carry over 40 hours per year, and employers can limit use of that leave to 40 hours, can employees bank leave and carry it over forever? So we proposed rules to clarify this, but the act doesn't specifically address this question. Employers can limit use to 40, and even part-time employees who may not accrue a full 40 hours are entitled to use up to 40 hours if they carry some over and have some in the bank. Can I make my employees take leave half a day or a day at a time? So the law says, unless you have a bona fide pre-existing policy, the highest minimum you can set for using leave is 2 hours. And I understand that's a bit of a contradiction, right? The highest minimum, but I think an example is helpful here to explain. So let's say you have an employee who wants to take 45 minutes of paid leave to run an errand or something. The employer may have a policy requiring them to use 2 hours. So you could say you can't just use 45 minutes, you got to use 2 hours at a minimum. But if you had an employee who wanted to take 3 hours of paid leave or something, you may not require them to take 4 or 8 hours instead. Okay, payout of unused paid leave upon resignation, termination. So this act, this is trying to thread the needle here. Paid leave for all workers act does not require payout of unused leave unless the leave is credited to the employee's general PTO bank or vacation amount. So if you're combining this leave in your accounting, if you're combining it with a PTO bank you have or a vacation bank you have, then you may be required to pay this out. Employers should also consider their vacation payout obligations under the Illinois Wage Payment and Collection Act. So think about this carefully, consult your attorney to see how this may apply to whatever leave plan you end up designing. Okay, back to Ganapathi for employer responsibilities.
Thanks, Anna. So what about pre-existing paid leave, paid time off or vacation plans? Again, an employer who has a bona fide pre-existing policy that allows all employees to take 40 hours of paid leave for any reason is not required to add to or change their plan. Nothing in this act shall be construed to discourage employers from adding or retaining paid sick leave, paid vacation, paid holidays, or any other paid time off or paid leave policy more generous than policies that comply with the requirements of this act. What are the record-keeping requirements for employers? So employers must keep records of each employee's hours worked, amount of paid leave accrued or provided, front-loaded, and the hours of paid leave by your workers used and when they used it. What is the record retention requirement? Employers must keep records for 3 years and also provide the Department of Labor access to these records. We are currently working on a public notice, a Know Your Rights poster that's required by statute, and we're hopeful to have it up on our website in the next, basically by the end of this month. So please check our website. And then employers of domestic workers, there are special provisions. Please see the act and consult your counsel if you employ any domestic workers. The employee handbook. Employees are advised to develop an employee handbook or personnel policy that clearly communicates any policies they want employees to abide by. Any such policies must comply with the Paid Leave for All Workers Act and any other applicable laws. This handbook must be in writing and distributed to all employees on or before the employee's first day. In the absence of a written handbook, the department will still conduct an investigation of whether an employer unlawfully denied an employee their rights under the act.
Okay. I also, before I get into retaliation, I want to address something that I think we've gotten some questions about. So if you're a township and you don't have an office, You maybe only have a couple of employees, you don't have a physical office. The Know Your Rights poster, the break room poster, as I call it, as well as the employee handbook. If you communicate with your employees, usually like electronically through email, whether you've got some kind of portal that they log into, the law allows, and we've proposed rules that, providing, if you have employees that you regularly communicate with electronically, that providing those sorts of required notices electronically is sufficient.
And if I could interrupt you there, I know that I'm going to get a lot of questions about this. We have several townships that have no computer. They do not communicate through email. 85% of our members represent populations of less than 5,000. And we've had a policy that we've indicated that if you had less than 5 employees, a handbook was optional. Now this will require it to be mandated, I believe. My question is, for those very rural townships with no computer access, what are you indicating as a guideline for an HR manual, or if they have, any guidance on that?
So, in terms of having a handbook, the law does not specifically require employers to have a handbook. I'm using the term handbook, employee manual, personnel policy. Those are all the same thing to my mind, whatever you call it. The law doesn't explicitly require employers to have a handbook, but it would be quite difficult, I would think, for an employer to administer this act without one.
I'm going to get the question of, I have 2 employees, one employee. Do I have to do this?
So to communicate to that employee basic stuff like, do you get the leave front loaded or accrue? Are you doing accrual or front loading? How do you want them to provide notice that they're requesting to use paid leave? If you want to establish any times when you might deny their request to use paid leave, that is the kind of stuff that you would want to put in a written policy. So if the employer is expecting or planning to sort of exercise any of those discretionary things within the act, it should be written down in the policy.
Thank you.
So, and then you would ask, what if they don't have computers? Presumably you communicate with your employee or employees in some way. Whatever method you normally use to communicate with your employee is how you should be, providing these required notices and documents.
Yeah, I would add, there's no requirement, and as I already explained, there's no requirement to have a policy. I would just look at a manual. Let me clarify, a manual, but I would look at our rules regarding, there are situations like, for example, if you're going to impose terms and conditions on the use of leave time, as we sort of talked about that regarding foreseeable and unforeseeable situations, then employers must adopt a reasonable written paid leave policy. And then there's also a record keeping requirement as well. So there are circumstances where, subject to the rulemaking process, that there are written documents, written requirements are mandatory.
Yeah. And we do not, the Department of Labor, we do not intend to provide like a template handbook or, a template policy. That's something that, employers need to design for themselves. But maybe that's a template or anything like that would not come from us at the Department of Labor. I'll just say that. Okay, I want to get into retaliation. And I know, so employers shall not consider an employee's use of paid leave as a negative factor in any employment action that involves evaluations, promotion, discipline, or counting paid leave under a no-fault attendance policy. So I think this section kind of addresses two things that are different from one another. So on one hand, an employer can't, fire someone for using the paid leave that they're entitled to. And that may sound like, oh, I would never, I would never do that. I would never fire someone for using, the paid leave that they're entitled to. But retaliation also includes any sort of penalty or discipline for using this leave, which could include if you have a points-based attendance system that leads to discipline for absences. Any instance when an employee is utilizing the paid leave that is provided under and protected by this act, those instances may not be counted against that employee if you have a points-based attendance system. Okay, penalties. So penalties and enforcement. So I'll go over the penalties and then I'll talk a little bit about enforcement. So there are a couple types of violations under this act. So you could an employer could violate the act in a way that affects a specific employee, such as unlawfully denying a request to use paid leave, failure to pay an employee when they've used paid leave. Any violation against affected employees may, entitle them to back wages, compensatory damages, a penalty to the employer of $500 to $1,000, or other relief as appropriate, the law says. Any violation of the act, except for public notice violation, may also result in a penalty payable to the department of $2,500. But then that failure to post public notice, right, the failure to put up the poster or provide that poster documentation to your employees, that's a bit lower penalty. That's $500 for your first offense and $1,000 for a subsequent offense. Regarding enforcement, I can say that, we would, if we receive complaints from an employee that their rights under this law were violated, we would review the complaint and assess whether to initiate an investigation. But also we always prioritize helping employers come into compliance rather than trying to be punitive if we can. We would rather help employers understand their obligations and how to come into compliance. And so, especially because we know this is a new law in the first part of 2024, that is our mindset. So some main takeaways again. Oh, back to Ganapathi for this.
Thanks, Hannah. So I guess three main takeaways from this. First, any employer who has a bona fide pre-existing policy that allows all employees to take 40 hours of paid leave for any reason of their employees' choosing is not required to modify the terms of their policy. Second, employers who are subject to the Paid Leave for All Workers Act may enact reasonable, clearly communicated policies that establish circumstances in which the employer may deny employees' request to use paid leave due to operational necessity. Employees should know where they stand and be able to plan ahead. Third, Department of Labor will be emphasizing employer compliance assistance for the first part of 2024. However, Department of Labor will still review every complaint to determine whether it warrants an investigation. The frequently asked questions were last updated on December 5th, 2023. So please do check our website. As we said earlier, we have proposed rules to clarify provisions of the Act. We do, like we've said, we do recommend both employers and employees, workers to review the website, not only for FAQs, but for our, eventually we're going to have our required public notice will be on our website, and also new and more information will be on our website as we get closer to January 1st, 2024 and afterwards as well. And also we do have a link posted below that'll take you directly to our FAQ to answer all your questions, and then any new questions as well. We're constantly reviewing our FAQ, updating it as quickly as possible to make sure that to help all employers to get in compliance with the act. Back to you, Anna.
Okay, so just so you can see, labor.illinois.gov, you go to our website, there's a header, sort of further down, Paid Leave for All Workers Act. You can click paid leave information.
Is this PowerPoint that you're showing us, is this on your website as well? I had that question twice.
We are talking about posting it in the days to come.
Okay.
Yeah, we're working on it. So we're very hopeful to get this. No promises, but we're very hopeful to get this up in the next week to 2 weeks. So
Great.
So please do check our website for a version of it.
And for people interested, I've recorded this, and unless IDOL objects, I'm gonna post this recording on our website so people will be able to watch it again if they wanted to.
Yeah, and this, so our web page here then that's where we would put the PowerPoint or anything else. You've got the email, which I'm the one who checks that email, so you can just ask me your questions now if we have time. But a link to the law itself, which may be helpful to read. Our proposed rules, which again, they're just proposed, they're not finalized yet, so just take them as guidance for now. But that'll give you a sense of our interpretation of some of the provisions, and then the FAQ. And then we are having more webinars. So if you are interested in seeing this again, or you have colleagues you want to send our way, we're having another webinar, Thursday? I'm doing that one, and then there's a couple more scheduled in January. It's going to be 99% the same as what you've seen today, but just in case you want a refresher or something, you're welcome to join us again. So now there's our info again, dol.paidleave and labor.illinois.gov. So I will stop sharing. I will try to stop sharing. How do I stop sharing? Oh, stop sharing.
Address this. This is a question. I'm going to get a legal interpretation from our attorney on the definition of an elected official, and I know that I feel pretty confident in my response to this, but I want to get it legally interpreted so that we have to validate are elected officials considered employees for purposes of benefits, and I don't believe that's true, but I want to get that in writing. Is the accrual of hours worked limited to a 12-month period for fiscal year? I think you covered that in your example. If they work 2 hours a month, for every 40 hours that they work, they get an hour off. Would you agree with that? If you've got employees that work 2 hours a week, once they hit 40 hours over however long it takes them, they get 1 hour off. Is this going to require township officials?
Can I interrupt? So it's based on hours actually worked, which means if you have people who are working overtime and are eligible, they're not management employees. If you have hourly employees who work overtime, count those overtime hours as hours worked for accrual purposes.
And then if you have township employees that work on an as needed basis, like snow plow employees in road districts, once they work 40 hours, they get an hour off. No full-time and no scheduled part-time work occurs. I don't know what that means. Of those employees, 2 cemetery administrators are paid $300 a year. Those would probably be considered management employees. I don't know how you deal with that. If they're considered a cemetery administrator, we'd have to look into that, I think, unless you have
There's a definition. If you go proposed rules, there's a definition of executive, a definition of administrative, and a definition of professional that you can review and consider, any given employee to determine if they qualify for that.
I think the reason that we need to clarify elected officials is there's no way to track the hours that they work. The AG opinion I'm referring to, I don't have it in front of me, but it refers to that an elected official is basically on call 24 hours a day, 7 days a week when needed, but I'll get that validated. Yeah. I think the lesson for our townships to take away today is The Department of Labor will have this PowerPoint on their website soon, if not sooner. Any questions? Anna said that she responds to that email inbox, so she'll be able to answer those. I think that it is someone asked us, when is the Department of Labor going to want to see these records? Is that only when a complaint is filed, or what's your opinion on that?
Yeah, only if we were doing an investigation, we have the right to inspect records.
Yeah,
like,
I would add that no, Department of Labor does not need a complaint to do an investigation. But I will also add though, like the first 6 months, we're really focused on employer compliance, right? This is a new law. We're gonna get a lot of questions. We're really trying to get employers in compliance so that workers can't exercise their rights under the act. So we're not trying to bring a heavy hand to this, right? To this act, but more of we're trying to answer your questions the best that we can. And then Anna's like one of the experts in the state on this law. So we're trying to provide as much support as we can to her, along with the other what was it? Other 28 laws, the Department of Labor, whatever the number is now, that we enforce. So
I can answer that one question there. And I mean, I want to go back to Jim's question at the top. Who is an employer? The township would be considered the employer if they have employees. That's, I think, by the definition. Will we provide a template? I'm going to talk to our attorneys and see. This was kind of new. The rules will probably, I don't know if you can tell us when they'll be adopted, but they did not utilize the emergency rule process, so they have a year to adopt them. I don't know if you're on the 120-day cycle.
My attorney normally doesn't like me to make promises, but I will tell you, it will not be a year. I'll
hold you to that.
The public comment period just closed yesterday, which means that we will be reviewing the public comments we received, preparing our responses, updating our draft of what we would propose for the second draft of the rules, second notice. And that is, I would say it is my intention to move those right along.
I can add that this is a priority for us.
So I think I appreciate that. Another seems to be a common question of the 28 that have been answered, but what if about accruing? Let's say that I've got an employee that works 5 hours a month. Once they get to 40 hours, they get an hour off. We get to the end of that year. Can you go over what happens at the end of that calculated year?
Yeah. So if they accrue, even if they've accrued very little,
4 hours.
They're entitled to use it or carry it over. In fact, it should carry over. We have proposed, I think, an FAQ interpretation that if the employee agrees to have it paid out at the end of the year instead of carried over, if both the employer mutually agree in writing that they want it to be paid out rather than carried over, we don't think the law prohibits that.
But an employer can say they don't want to pay it out.
Right. And the employer can say no, or the employee can say no. I want to carry it over.
I can calculate their hours, but for an employee that only works as needed, how can they ask for time off when they may only work 5 hours a month?
Well, if they work 5 hours a month, 40 hours, when you work 40 hours, you start accruing 1 hour.
Well, after
right?
after 7-8 months, they'd have 1 hour off.
Yeah.
So we are working on a template. No offense to the Department of Labor, we had hoped for a veto session success that would have extended the effective date, but we didn't get that done. But so now we have information in the current Perspective magazine about this. We'll be working with the Department of Labor on other programs or once the rules are adopted, or I know that Anna has offered to work with us, myself and Brad, to assist any of our members who have questions. Oh, there's a bunch in there. Now, you want to go through some of those, Anna?
Yeah, so there's a couple questions about fire protection districts, and I typed a response to this, but I'll say to everybody, fire protection districts, this is going to sound like a non-answer, but it really is an answer. Look at the definition of employer to determine if they are an employer. So that's one thing. And then step 2 is, do they have any employees? This is a question I get frequently. Are volunteer firefighters employees? And again, look at the definition of employee, analyze it with respect to your volunteer firefighters, or anybody else that you're like, it's not clear, and have your attorney make an assessment and say, yes, this person meets the test of employee, therefore they need to be covered, or maybe not.
Yeah, and Jerry, I know it's not every township has an attorney, so we sort of recognize that, but at the same time, like, we can't provide legal advice. So we can only give the guidance to the extent that we can. I mean, obviously, we'll, like, when we get these questions via email and like this, we'll do the best that we can to sort of steer everyone in the best direction.
And I appreciate that sincerely. We've got time for a couple more questions. We're a little over an hour, but this is a good one. I want to make sure we answer this because I think this is one that could help everybody. How does this work if you already have sick and vacation time? And I think that you said it earlier, but let's restate that. It may help.
So, okay, so I'm rolling up my sleeves. So we have proposed in our proposed rules a term that is qualifying pre-existing plan. And in that definition, it is if you have a pre-existing, so before January 1, which could include between now and January 1, right, making some changes or something. If you have a qualifying pre-existing plan that allows all employees to, in fact, take 40 hours of paid leave every year for any reason of their choosing. I'm counting off the factors, right? Pre-existing, all employees, 40 hours every year, any reason of their choosing. You, in fact, which means, you know, it's not just a policy on paper, right? They actually get to take it. Then the employer doesn't need to modify any terms of their policy. So if you say, you know, does my vacation policy, my pre-existing vacation policy qualify me for this provision that says I don't have to change anything? Maybe, yeah, maybe. Take a look at that definition, talk to your lawyer, talk to a lawyer, and see, like, if it meets the test, then you may not have to do anything. But I would encourage you, and this is not required, this is just me talking, if you think that you have a qualifying pre-existing plan and you're not planning to add anything or changing anything, I would communicate that to your employees, because otherwise they might be asking, right? Or they ask us. And keep records documenting that you have that qualifying pre-existing plan, just in case there is ever a dispute with an employee. You would want to be able to show, like, look, nope, here's why I think I have our vacation plan already qualifies, or whatever it is.
Last question, and then we'll try to wrap it up. Does this start accumulating on day 1 or after a probationary period? I think you mentioned that.
It starts accumulating on day 1, but there's a 90-day, it starts on day 1, but you can have a 90-day waiting period for them to actually use it.
Yeah. And
now, thank you, Anna, and thank you, Ganapathi. I want to make sure I say your name right. I know on behalf of the Township officials of Illinois, our board of directors, and myself as the executive director, I want to thank our representatives from the Department of Labor. I know that this is a very monumental task. The rules, we have a copy of them. I can put a link to the administrative code on our website. If people want them, let us know by emailing Brad or myself. We are going to put a series of informational items in our Perspective magazine that's published in 2024 as this rolls out. And I know that the Department of Labor already indicated, but there'll probably be more webinars if you wanted to watch this again, or as the rules go through and the informational packets are sent out, or the posters that you can post in your workplace. But this is a new area, both for township government, municipal government, governments of all sizes, and also for the Department of Labor. It's a whole new program. I'm sure the emails are flooded, but we are committed to helping our members get the information that they need and comply with the law. So, closing comments, Anna or Ganapathi?
Just appreciate the opportunity to speak with you. We appreciate and understand that you guys are here because presumably you want to comply and you're, that's your intention to understand your obligations. So we really appreciate that. Again, follow-up questions can go to the email. I answer those in the order that I get them, and I have a lot. So I appreciate your patience. It's if I don't, just because I haven't gotten back to you doesn't mean I missed it or I'm ignoring you.
Yeah, I just want to say thank you for your time. Really appreciate it. We're happy to answer questions and look forward to being partners in the future.
Thank you very much, everybody. Have a great day and a happy holidays, and we'll to be continued, I'm sure. Thank you.
So take care.